Hi, this is Mr. Seymour, and this week's lecture is on the topic of federalism, which is looking at the balance between the powers of the national and the state governments and the local governments. We have to share these powers, and that's where federalism comes in as a concept. So the first thing we want to do is look at the powers that are specifically given to the national government. We call these express or explicit powers. Then we want to look at those that are allowed to the states and those that are shared by both. We also want to look at the powers that the national government cannot exercise and those that the state governments cannot exercise. So the first thing we want to do is look at the national governmental powers. And the first power is the power to print money. Secondly, the power to regulate interstate commerce and international trade. Now, this is a very important power because it gives the federal government a lot of leeway, and we'll look at that in a minute. The power to make treaties and to conduct foreign policy. The power to declare war. The power to provide for an army and a navy. The power to establish post offices. And then the part that allows us, or the federal government, to exercise the rest of its powers is the powers to make laws that are necessary and proper to carry out the other powers. We call this the necessary and proper clause, otherwise known as the elastic clause. So what is federalism? Well, let's go back for just a second and take a look at the rest of this chart. State governmental powers. The powers to grant specific licenses, like the right to teach, the right to practice medicine. The power to regulate intrastate commerce, that's within the state. The power to conduct elections. Only the states conduct elections. The federal government does not actually conduct elections. The power to establish local governments. The power to ratify amendments to the state constitution and to the federal constitution. The power to promote public health and safety. And the states may exert the powers that the Constitution does not delegate to the national government and does not prohibit the states from using. So if it isn't specifically given to the national government, it's supposed to go to the states. Concurrent powers. Both the national and the state governments have the power to collect taxes. They have the power to build roads. They have the power to borrow money. They have the power to establish court systems, to make and enforce laws, to charter banks and corporations to practice within the state or at the national level, and to spend money for the general welfare, to take private property for public purpose, and to give just compensation for that property. That's the one requirement in the Fifth Amendment. Now, the national government may not violate any of the Bill of Rights. The national government may not impose export taxes among the states. So you can't impose a tax on a good going from one state to another. They cannot use money from the Treasury without the approval of Congress, the House of Representatives specifically, and they may not change a state boundary. The states may not enter into treaties with other countries. They may not print their own money. They may not put taxes on imports or exports into or out of the state. They may not interfere with contracts. And they may not suspend a person's right without the ability to have due process. So the question of federalism: should the government require all Americans, for instance, to have health insurance? While individual Americans disagree about this question, the states and the federal government disagreed about whether Congress should be able to force the states to implement the Affordable Care Act, otherwise known as Obamacare. this is one example of the disputes that lead themselves out of federalism, because federalism requires a system of government where the power between the states and the federal government are divided and shared across at least two political units. Sovereign power means the amount of authority and autonomy that each unit is given or exercises, because in some cases it's a matter of taking the power rather than having it specifically given. Federalism is a balancing act. It is required a level of cooperation, and you're seeing a balance between the state and the federal government. Congress cannot create, for instance, a national drinking age, but Congress can withhold federal highway funds from any state that does not comply with implementing a national drinking age. So, in a sense, Congress is setting a national drinking age at 21. Congress cannot establish on the states that 0.10 or 0.08, now they're trying to go to 0.08, are the levels of intoxicated driving. The states have to do that. But the federal government can say, if you don't go to 0.08 in your laws by X date, we're going to withhold money from you in your highway grants. So they do have power to influence state-level politics, and that's important to understand. So the sharing of power is the basic element of federalism. State governments are not responsible for national defense or foreign policy. Federal governments are not responsible for issues like allowing smoking in bars or restaurants. But do the two often meet in the middle? Yes. The underlying question becomes, should governance in the United States be more nation-centered or state-centered? Right now, we have seen a shift towards nation-centered central government authority. That is kind of contrary to the idea of federalism, and it's contrary, I think, to a lot of the ideals that the Founding Fathers had. So we need to look at why we've gotten to that point. How? Unitary systems are systems with strong central governments, whereas confederations are centers with strong state governments. We were a confederation prior to becoming a federal republic. Unitary systems are a lot more common because the federal government can be more complicated. Issues of division of power don't come in. The unitary is more centralized. They tell the states what to do. It's just easier to implement those systems. It's a lot more complicated to implement a system of federalism. The concepts that support the idea of a stronger national government. First, let's look at the Constitution. The Constitution opens with, "We the people of the United States." Remember, that has to do with sovereignty, popular sovereignty, who's in charge. The founders intended for a less state-centered government under the Constitution. They wanted the federal government to have some level of control because it wasn't working prior to the implementation of the Constitution. The second thing is we have the Necessary and Proper Clause, which is Article 1, Section 8 of the Constitution. This clause gives Congress the authority to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. What it really is, we call it the Elastic Clause because you can stretch it. Now, the Supremacy Clause is Article 6, which says that the Constitution is the supreme law of the land, and that the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding, meaning that the Constitution comes first, then the federal laws, then state constitutions, then state laws and ordinances, then local laws and ordinances, in that order. Your enumerated powers. These are the powers that are specifically given to Congress, and they include admitting new states, declaring war, coining money, creating and maintaining an armed force, regulating commerce with American states and with foreign countries. It's the Commerce Clause that gives the most power to the federal government, and we'll see how that works in a minute. The Privileges and Immunities Clause is in Article 4 of the Constitution. That's the part of the Constitution that deals with the relationship between the states. It says that the states must treat citizens of another state in the same way that they treat their own citizens, with a few exceptions. One of them that has come to light under court cases has been that colleges can charge out-of-state tuition to those not from that college's state. Another is that only citizens of a state can vote in that state's election. Then we have marriage licenses and professional licenses. For instance, the state of Texas has to acknowledge the license of a doctor coming in, but they can require that that doctor pass their state exam in medicine before that doctor practices medicine. The same for law. The same would go for any professional license. Now, marriage licenses are very unique as well, because the courts have said that the states don't have to acknowledge the marriage license from another state, but most states do, with a few exceptions. And one of those has been under the Defense of Marriage Act, which says that the states, if they put it in their state constitution that same-sex marriage is forbidden, they do not have to acknowledge same-sex marriages. This leads to a tremendous number of complications. So let me give you a scenario. You get married in Massachusetts, same-sex marriage. They adopt a child or two. And in the process of taking care of that child, they've decided the marriage isn't working out. Now, we have a case where a couple moved with children to Austin, Texas, and they wanted to get a divorce. And the state of Texas said that they could not get a divorce or decide custody because their marriage wasn't valid. It wasn't recognized. So how could they give a divorce to a marriage that wasn't recognized? So they told them they were going to have to go to Massachusetts. They didn't want to have to go back to Massachusetts and establish residency for 18 months there. So how do they get a divorce? How do they take care of the custody of the child? What do you do when a spouse dies? All of these become very important concerns. Whatever you're feeling about same-sex marriage, the legal ramifications, because some states are acknowledging it, others are not, the legal ramifications are tremendous. And they deal here with the Privileges and Immunities Clause. Privileges and Immunities Clause. So let's look at some concepts that support a stronger state government. The first is the 10th Amendment, which says that the powers that are not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states or to the people. Which means if it isn't forbidden, if it isn't specifically given to the federal government and isn't forbidden to the states, it belongs to the states. Good example, education. 11th Amendment prohibits citizens of one state from suing the government of another state. The Full Faith and Credit Clause is part of Article 4 of the Constitution that requires that each state's laws be honored by other states. Like a legal marriage in one state needs to be recognized across state lines. But the Defense of Marriage Act, passed in 1996, says that it doesn't apply to homosexual marriages as long as the state has put it into their constitution. So let's look at the evolving concept of federalism as it's gone through the courts. We start with probably the most famous court case that gives the Supreme Court its powers, which is Marbury versus Madison in 1803. It creates the concept of judicial review, which is where the courts give themselves the power to overturn laws based on the constitutionality of those laws. The second case that came in front of the court was McCulloch versus Maryland in 1819. This upholds the right of Congress to create a Bank of the United States because it said that Congress had the power under the Constitution to establish banks and to regulate interstate commerce. Gibbons versus Ogden even more broadly defines the regulation of interstate commerce. Now, interstate commerce becomes the way by which the national government can use the supremacy clause and especially the elastic clause more often than not. It gives them the power to give themselves authority where they didn't have it. And so that's why we've seen a shift towards federal power in this relationship between the federal government and the states. Now, the Dred Scott decision, a highly controversial case that dealt with the national debate over slavery. It said that the Congress did not have the right to ban slavery in a U.S. territory, and it also said that, as it says in the Constitution, if a slave goes to a free state, that slave has to be returned as property to the state from which he originated. Now, the next important federalism case was Brown v. Board of Education, which invalidated racial segregations in schools, and it led to the unraveling of what is called de jure segregation, or legalized segregation. De jure segregation is when you make a law to segregate people. Roe v. Wade, 1973, is today's most controversial case because it legalized abortion during the first trimester, and it is at the center of most of our current controversies dealing with pro-life, pro-choice advocacies, and it has a lot to do with the differences between current Republican theology and Democratic beliefs. All right, a few more cases. The case of Chisholm versus Georgia in 1793 holds that citizens from one state could sue another state, led to the 11th Amendment, which prohibited these lawsuits. McCulloch versus Maryland in 1819 upholds the national government's right to create a bank and to reaffirm the idea of national supremacy. Gibbons versus Ogden in 1824 holds that Congress, rather than the states, has the power to regulate commerce between states. Barron versus Baltimore in 1833 endorses the notion of what we're going to call dual federalism, where the rights of the U.S. citizen under the Bill of Rights does not apply to that same person under state law. It will change by the early 1900s, and we're going to see a process called incorporation, where the 14th Amendment will be used to implement the Bill of Rights and its protections to the individual at the state level. Dred Scott versus Sanford says that slaves are property. It rules that the Missouri Compromise violated the Fifth Amendment, since making slavery illegal in some states deprived slave owners of their property, and it contributed to the start of the Civil War. And then the National Labor Relations Board versus Jones and Laughlin upholds the National Relations Act of 1935 as being consistent with Congress's Commerce Clause powers. It reverses the court's interpretation of that clause, and it broadens the Commerce Clause even more. So we're going to look at the types of federalism, and your book mentions 6 different types and how we've kind of moved from one to another. The first type we had for well over 150 years, which was dual federalism, what we're going to call layer cake federalism. This is where the national and the state governments are viewed as 2 distinct entities with very little overlap. So if you think of a cake where you have maybe a chocolate layer separated from a vanilla layer separated from a strawberry layer, each layer would be a layer of federalism. They're distinctly separated from each other. Now, if I mix the chocolate and the strawberry in with the vanilla and put it all in one big cake, what I've made is a marble cake. And marble cake federalism is when we mix or share those powers between the states and the federal government. Cooperative federalism is another name for it. It starts in 1937 in the middle of the Great Depression. It says that there needs to be a level of greater cooperation and collaboration between the levels of government, because the federal government starts to use its power of the purse to get more involved in the day-to-day operations of the states. Now, picket fence federalism. This is a version of marble cake federalism or cooperative federalism that emphasizes policymakers within a given policy area have more in common with others in their area at different levels of government. And so what you see is picket fences separating these areas of government with different issues. So you have the issues dealing with, for instance, due process. And you might have issues that deal with gay rights. And you might have issues that deal with education policy, and other issues that deal with healthcare policy. And we see them separated by picket fences. Fiscal federalism is a system of transfer of payments or grants from the national government to a lower level government involving various degrees of national control over how the money is spent. We have categorical grants that give the national government a lot of control, and block grants that give the states more control. And we've seen the use of categorical grants and block grants and revenue sharing, and we'll talk about all three of those. Under New Federalism, this was an attempt to take the power and give it back to the states by taking these categorical grants and making them block grants and giving the states more authority. This begins what's a process of what is called devolution. And devolution is where the power is given to the states and the responsibility to fund is given to the states. Now, under coercive federalism, this is carrot and the stick. This involves federal preemptions of state and local authority and unlawful mandates, many of them being unfunded, meaning there's no money that goes with the mandates. Okay, unfunded mandates on state and local governments to force the states to change their policy to match national goals or the policies of Congress. So a good example would be highway funds and drinking laws. Another would be education. The fact that the federal government contributes to Title I in education and gives money to the schools means that it has taken a lot of authority over the education process that it was never given. So in the early 1800s, the Supreme Court confirmed that the right of the national government was to regulate commerce between the states, and the state of New York granted a monopoly to a ferry company serving ports in both New York and New Jersey. But this ferry company was found to interfere with interstate commerce, and then it became told that it was subject to federal intervention, which means that since it dealt with the relationship between two states, the federal government could tell them what to do. The Supreme Court recently overturned Article 3 of the Defense of Marriage Act, which allows for federal recognition of same-sex marriages in those states where same-sex marriages are legal. But it doesn't fix the problem of the states that refuse to recognize a same-sex marriage, like Texas. So the question becomes, at what level will this problem be solved? Is it going to be the courts? Is it going to be an amendment to the Constitution? Or are we going to let the states continue to decide, and in that process have different laws that apply in different states? Franklin Roosevelt and his New Deal was responsible for shifting more power than ever to the national government through the power of the purse. Through major new programs that addressed the Great Depression, his federal government policies would be used to expand the reach of the national government, and we spend a lot more money on these programs starting in the 30s, and we see them today because the states become addicted like crack cocaine to the federal spending on grants, categorical grants. So it expands the power of the purse. And here you see a cartoon where he says, "Old Reliable, pulling the rabbit out of the hat, government spending." This is one rabbit that never failed me, because it's a way for the government to get their fingers into the reach of states. So here's a rather attractive example of the layer cake model of federalism, where you have the powers of the federal government, the state government, and the local government distinctly separated. And so you can see that these layers do not overlap. Whereas in the marble cake example, we mix them together so that we have the federal, the state, and the local. And in picket fence federalism, we have our policies: federal, state, and local education policy, federal, state, and local healthcare policy, public safety policy, housing and urban development policy, highways and road policies, finances and taxation, drug policy, social services policy, environmental policy, and so forth. So there are three characteristics of American politics that have led to a reinforcement of the need for, or the purpose of, a strong national government. The first is that we always tend to look to the national government during a crisis and during war. The second is that the civil rights and economic rights struggles of the Great Society led to more need for government intervention at the federal level. And the third has been the use of coercive federalism, carrot and stick, through federal regulations and mandates that require states to change their policies, or to either to have money taken away from them, or if they don't change their policy, if they change their policy, they get money. In today's globalized society, the question is local or even state government really relevant, or is it all about national government? Should we still have this system of federalism? When we talk about carrot and stick federalism, the carrot right here is used to get the donkey to move forward by promising him something, enticing him. So the carrot is financial enticements and grants to the states that do what the federal government wants them to do. Now the stick is applied to the reverse side of the donkey, and it gets the donkey to move when he doesn't want to move by punishing him. And federal government withdraws financial support from the states that do not comply with federal requirements. States have fought for both progressive and conservative causes, and competitive federalism is one result. Competition among the states to provide the best policies to attract businesses, often called race to the top, sometimes called race to the bottom. We'll look at that. Competitive federalism can be a good thing, as it allows people to, as they say, vote with their feet by going to the states that offer the better services, but critics have said that it can lead to a race to the bottom, where states compete for unhealthy ways that lead to social ills. So let's look at a sample here. This is a cartoon that was in the Washington Post, I believe, not too long ago. And it says, grocery chains, we have to compete with Walmart, are chasing after Walmart. And it says, faster, faster, we need to compete with them. And they're chasing after slave wages. So shrinking wages, evaporating benefits, are these the kinds of anti-progressive policies that we want to see happening over the course of our lifespan? Because a lot of states are saying, well, look at Texas, it's very attractive, we've got so many people moving here. That's because we're giving a lot of benefits to the businesses to move here, and we're kind of selling ourselves short, and that's race to the bottom. Another important question we need to look at is the issue of state powers and limitations on national powers. From the 1930s until the 90s, the 10th Amendment was basically unused. It was dormant. Since the 1990s, people have been going back to the states' rights argument saying, hey, wait a minute, federal government, you've taken too much away from us. So let's look at two important cases where the 10th Amendment was used appropriately. First, Prince versus the United States. The Supreme Court cited the 10th Amendment when it said that the federal government could not force local governments to perform a background check on local gun buyers. But the federal government went one step further and established a federal background check database anyway, and so they found another way around the problem. In another victory for advocates of states' rights, the court struck down the Gun-Free School Zones Act of 1990, which used the Commerce Clause to say that the Congress could only regulate activity related to interstate commerce. And it was trying to use the Commerce Clause to say that a man or a boy, a senior at a high school in San Antonio, who was arrested for carrying a concealed weapon onto campus, was somehow violating the Commerce Clause. And they said, wait, you've stretched it too far. Now you can't use the elastic clause in the Commerce Clause. This much, you're going to have to take a step back. And they said, no, you can't do that. Now, can you establish safe zones and say that it's illegal to take a gun onto a public school campus? Of course you can. But you can't use the Commerce Clause to justify it. The Lopez decision would strike down the 1990 Gun-Free School Zones Act, and which was the ruling that Congress did not have the power to forbid people to carry guns near schools. After the Columbine shootings in 1999, there were renewed calls for nationwide strengthening of gun control laws. But we have this thing called the Second Amendment, which makes it very difficult to implement those laws. So let's look at the role of the Supreme Court today. While 14 states have passed medical marijuana statutes that legalize cannabis as a remedy for sick patients, and now we have 2 states that have made it totally legal for recreational purposes under a certain quantity or amount, marijuana is categorized as a Schedule I drug, a highly dangerous drug with no medicinal value. It is prohibited. So a case came before the Supreme Court in 2005 called Raich v. Gonzalez. It was a national power liberal, It was a debate over the national power that liberals and social conservatives would have in the case of compassionate use. The liberals are saying you should let us, at the state level, have the ability to use marijuana. Of course, a lot of the conservatives wanted medical marijuana to be forbidden. It is widely prescribed in California, widely used in California, and of course now in Oregon and in Colorado, it's legal completely for recreational use. And what happened with this ruling was that they said that the states did not have the right to legalize marijuana because the federal law was superior to it. So they used the Supremacy Clause. They also used the Commerce Clause, saying that these little ladies had their 6 plants, even though everything was within the state of California, that these little ladies in their 6 plants had somehow interfered with interstate commerce because the money would have somehow passed over state lines anyway. And they really had to reach to implement this law and to enforce this ruling. And what the Supreme Court really was saying, if we don't use the Commerce Clause, we have no way of regulating drug laws. Now, other revived states' rights strategies has been the 11th Amendment, which says, hey, you can't do this against a state. So the states are saying, federal government, you can't do this to us. The 14th Amendment, as interpreted, limits remedial legislation or legislation that's intended to fix a problem. But that's debatable because it also talks about equal opportunities under the law. Remedial legislation means national laws that address discrimination. And so they're trying to say, the states are trying to say that the 14th Amendment is being overused. So what are the advantages of a strong state role in federalism? First, the states can act, this is right out of the Republican playbook here, as laboratories for democracy. Secondly, state and local governments are closer to the people and can be more responsive to local demands. Third, states provide more access to the political system. And fourth, states provide a check on national power. Now, remember we talked about devolution, and we also talked about states' responsibilities. I want you to see that some states like Alaska, Washington, D.C., which isn't really a state but a territory, Wyoming, New York, they spend a lot per capita, but they also have small. Some of them have smaller populations on state spending. But states like Texas, which is over here, don't. So in Texas, if we don't take the state money or the federal money, we just don't pay for it. And a lot of times now we're saying no to the federal money, and we're just not paying for things. So we are really chintzy in our state. This is the national average on poverty levels. Those below the poverty line. On a national average, about 17% of the population is below the indicated poverty line. But I want you to see that in Texas, the number is considerably higher. It's over 20%. So when we look at per capita income, federalist systems that give too much power to the states have at least three problems. First, there's an unequal distribution of resources. Secondly, an unequal protection of civil rights. And third, competitive federalism can lead to that race to the bottom that we talked about. So let's look at some versions of federalism here. We have our marble cake federalism, our layer cake federalism, and our picket fence federalism. And then coercive federalism. In layer cake federalism, we separate those layers of authority. In marble cake federalism, we mix them together. In picket fence, we go by policy type. And in coercive, we use the carrot and the stick and give more responsibility to the federal government. So in layer cake federalism, there's no interaction between the levels of government, or very little. In marble cake federalism, the interactions between federal and local governments and state governments are very common and intermixed. In picket fence federalism, horizontal pickets or boards represent levels of government that connect different policy areas. Coercive federalism is national government using regulations, mandates, and conditions to pressure states to fall in line with national policy goals. So let's look at a couple of other things here. This is federal, state, and local government spending from 1946 to the year 2011. I want you to look here. This is the blue. Look how it's gone up. The red, look how it's gone up. Okay, that's the state and local, and then this is the use of grants. So overall, government spending is going up. That's the trend. Now, do we ever look to the federal government in the case of an emergency and say, you come in and fix it? This is Hurricane Sandy here. But what about Hurricane Katrina? Hurricane Katrina was a disaster because for 3 days, the federal government didn't step in and help. Other than fishing a few people out of the water, they didn't really help, and people were dying. In the debate right now over health care reform and the Affordable Care Act, the supporters of nationalized health care are arguing that the federal government can do a better job than each state having its own laws to ensure that Americans receive a sufficient amount of care. Of course, the states argue that it's an undue burden on the states. So again, this is that same federal and state and local spending figure that I showed you earlier. That shows that federal, state, and local spending is going up. Now, the Americans with Disabilities Act requires that public accommodations and commercial facilities have, for the handicapped, you have to have handicapped accessible accommodations. But recent rulings of the Supreme Court have held that this does not apply to most state and local government buildings because of the 11th Amendment. Disabled activists here are lobbying for stronger legislation in front of the White House. Then we have No Child Left Behind. No Child Left Behind, which was implemented by George Bush, increased the national government's power over education through the power of the purse. States are required to test students and to meet goals determined by the federal government in order to continue to receive money from the federal government. This is in 2004, right after the implementation of No Child Left Behind. This is a cartoon. It says, "Look, class, I'm not crazy about this either, but what really frosts me is we have to pay for the hoops. So we're making all the kids go through the hoops, and now the teachers and the schools even have to pay for the hoops because they're unfunded mandates." But here's something that's really interesting from the Cato Institute that goes back to about 2011. This is the cost of education, federal spending and state spending all together, the cost of educating students. Okay? These lines are the results that we're getting on tests. And what we're actually seeing is that the test scores are flat, or that the test scores are going down in some respects. So the question is, has No Child Left Behind even worked? Does the federal government belong interfering in education? Here's a few more recent Supreme Court decisions. The Gregory versus Ashcroft decision of 1991, where the Missouri Constitution's requirement that the state judges have to retire by age 70, they said it did not apply, did not violate the Age Discrimination in Employment Act. So that one sided with the states. United States v. Lopez of 95, carrying a gun in a school did not fall within interstate commerce, and Congress could not prohibit the possession of guns on school property. But they could sure push the states to. Seminole Tribe versus Florida says that the court used the 11th Amendment to strengthen the state's sovereign immunity, ruling that Congress could not compel a state to negotiate with an Indian tribe about gaming and casinos. Prince versus the United States in 1997 strikes down part of the Brady Handgun Violence Prevention Act that says that Congress cannot require local law enforcement officers to perform a background check on a prospective handgun purchaser. But of course now we have a federal background check system, and they are using that system. City of Bernie versus Flores, court strikes down the Religious Freedom Restoration Act as an overly broad attempt to curtail the state-sponsored harassment of religion, saying that national legislation aimed at remediating states' discrimination must be congruent and proportional to the harm, meaning that you can't use the 14th Amendment at your own will to force the states to do something to say that it's because you're doing it for anti-discrimination. Aldean versus Maine, state employees could not sue the state of Maine for violating the overtime pay provisions of the Federal Fair Labor Standards Act, which would mean they're using, or they're referring back to the 11th Amendment here, that you can't sue the state. United States versus Morrison, the court struck down the Violence Against Women Act, saying that Congress did not have the power under the Commerce Clause to provide a national remedy to gender-based crimes. Then you have Kimmel et al. Versus Florida Board of Regents. The Age Discrimination in Employment Act of 1967 could not be applied to state employees because it was not considered appropriate legislation under the 14th Amendment. Alabama versus Garrett, the court strikes down the portion of the Americans with Disabilities Act that applies to the states, saying that state governments are not required to make special accommodations for the disabled. Nevada Department of Human Services versus Hibbs, the court would uphold Congress's power to apply the 1993 Family Leave Act, FMLA, to the state employees as appropriate legislation under Section 5 of the 14th Amendment. So this one did side with the federal government. United States versus Bond in 2011, the court upholds individuals' rights to challenge the constitutionality of a federal law under the 10th Amendment. And National Federation of Independent Business versus Sebelius, the court upholds the most provisions of the Affordable Care Act, which is Obamacare, but it strikes down the expansion of Medicaid as an unconstitutional use, of course, of federalism. And Texas, for instance, did not buy into the expansion of Medicaid. We have decided not to take that money because we're concerned about carrots and sticks. And that is the end of our lecture for this week. See you next week.